federation. And I'll be speaking on the chapter 1. So in speaking to our seminar paper is divided into 5 parts with their different divided into 7 parts with their different headings. So I'll be taking part 1, which is the general introduction and definition of terms. Please, can you all hear me?
I can hear you very well.
Okay.
Yes, I can hear you.
I can hear you. Please, we can hear you.
Thanks so much. So I'll start with our abstract, as we believe that the abstract gives a concise summary into what the whole paper contains. In our abstract, we had mentioned that the paper examines the interstate and international dimension of conflict of laws within federal system, focusing on Nigeria, Canada, and the United States of America, so as to speak to the comparative part of our seminar topic. It explores how constitutional structures, state autonomy, and judicial interpretation shape the resolution of cross-border legal disputes. The paper highlights the United States' reliance on the full faith and credit clause, Canada's emphasis on provincial autonomy and judicial doctrines, and Nigerian challenges arising from legal pluralism and institutional centralization. So, as I earlier mentioned, through comparative analysis, the paper reviews significant differences in approaches to jurisdiction, enforcement of judgments, and legal harmonization. It concludes that effective management of conflict of laws in federation requires a balanced framework that promotes state autonomy while ensuring legal coherence, supported by judicial cooperation and institutional reform to enhance certainty and stability in the increasingly intercontinental or connected world. So not to bore us, I move straight to the introduction. The group 1, group 2, as presented before us, have been able to define what conflict of law is and the branch of law it belongs to. So we reiterated there that it's known as private international law, and is the area of legal study that addresses the complexity that arises when legal issues cross jurisdictional boundaries. And I remember that in one of the classes, our lecturer had mentioned that while it looks as if humanly or by human nature, we don't pay attention to boundaries, like geographical boundaries as it is. When it comes to disputes, when it comes to conflict of law, it becomes a very germane thing to look into. So in federation where multiple levels of government coexist, the interplay between interstate and international dimension of conflict of laws become particularly significant. So the comparative analysis focuses on Nigeria, Canada, and the United States of America, 3 diverse federations that grapple with conflicting laws both within their respective states and at the international level. So we understand that when it comes to federal system, we have pluralism of laws, because at the federal level, it has the highest lawmaking body, which is the National Assembly, that makes law, and the states equivalent as well for different states. So let's take Nigeria, for example. All of the 36 states in Nigeria have laws that governs them. And that is what conflict of law tries to look at when we talk about interstates, when these laws conflict, where there are issues between 2 states and how to resolve them. So in Nigeria, the legal landscape is shaped by a combination of statutory laws, customary law, and Islamic law, creating a unique environment for conflicts of law. So Adela mentioned, I'd only said that we have different laws, and specifically, these laws can be divided into customary, Islamic, and statutory law. So the Nigerian legal system operates under a federal structure in which states have the authority to enact laws that may occasionally conflict with federal statutes. So I'm also going to explain this, because when I mentioned, I only said conflict between states. And it also happens that there can be conflict between the federal, the FCT, and any other state. So this is where conflict of law is very important. So this can complicate the determination of which legal provisions apply in cross-border cases, particularly in areas such as family law, property rights, and commercial transactions. The interstate dimension of conflict of laws in Nigeria is further complicated by ethnic and religious diversity, making it essential to consider how these factors influence our legal outcomes. In northern states, Islamic law governs them. And if you look at our Marriage Act, not even the Marriage Act, let me say the penal code now, adultery is an offense in the northern states. For the western states, it is not an offense. So when something like this occurs, when we have something of this class occurring, how does it get resolved? If there's adultery between a southerner and a northerner, how is this dispute resolved? So this is one of those things we consider in conflict of law. So the interstate dimension of conflict of law in Nigeria is further complicated by ethnic and religious diversity, making it essential to consider how these factors influence legal outcomes. By contrast, Canada's approach to conflict of law reflects its historical ties to both the British common law and the French civil law traditions. The Canadian legal framework provides a robust mechanism for resolving interprovincial and international disputes. With its commitment to multiculturalism and protection of minority rights, Canada's legal system emphasizes the importance of harmonizing laws across provinces, while also addressing conflicts with international legal obligations. The interplay between provincial autonomy and federal oversight creates a dynamic environment for conflict of law, particularly as Canada engages with its international partners on trade, human rights, and environmental issues. So I've been talking about interstate disputes. Now, the international dimension of conflict of law as well, what mechanisms are put in place, how are conflicts at this level resolved? And we look at it that the Canada has a strong framework which it use the mechanism of provisional autonomy. And we check that US use full faith and credit clause in matters that have international flavors. Now, elaborately, the United States presents yet another distinctive perspective of the conflict of law within a federal system. The US Constitution grants states significant legislative authority, resulting in a patchwork of state laws that vary dramatically, particularly in areas such as tort, contract, and family law. The federal government also plays a crucial role in international relations, often impacting state laws and their application. The US legal system addresses conflicts through mechanisms such as, please let's take note, full faith and credit clause and the supremacy clause, which guide how states must respect each other's laws and how federal laws interact with state legislation. By comparing these three federations, we can uncover both the challenges and innovations in addressing the interstate and the international dimension of conflict of law, highlighting the diverse approaches that inform legal practice and policy in a globalized world. Thank you so much. And before I conclude on my part one, it's important that for us to understand any concept or for us to understand any subject matter, terms or keywords that are used are given definition. It also shed more light on understanding that. So here in 1.2, we have definition of terms. I've already defined conflict of laws initially, so I will not want to bore us with that. So let's understand what it means by interstate conflict of laws. Yes, I know I'd mentioned it, but let me read it. Issues that arise when a legal dispute involves parties or elements from two or more states within a federal system, necessitating the determination of which state laws should apply. International conflict of laws now, similar to interstate conflict, it involves parties or elements from different countries requiring resolution of which nation laws apply. Now, federation, I want to believe you all know it, but let me say it. It's a political entity characterized by a union of partially self-governing states or regions under a central federal government, where power is divided between the central authority and the member states. And this is one of the federal structure creates, it's a unique environment for conflict of law because of the pluralism of law on different law at federal level and at the state level. Now, jurisdiction is the legal authority of a court or other body to make decisions and enforce laws within a specified geographic area or over certain areas of legal cases. Now, federal law, the body of law created by the federal government of a federation, which has supremacy over state laws. It matters within its constitutional purview. Private international law, a branch of law that deals with private individuals and legal entities, covering issues such as contracts and torts that cross international boundaries. Public international law, just for us to know the difference. The body of law that governs the rights and duties of states and international organizations in their interaction with one another. So I want to move close to full faith and credit clause before my other members come, because one of the mechanisms for disputes for conflict of, for applied to conflict of law at the international level in or between US and its states and the states under it. A clause in the US Constitution requiring states to respect the public acts, records, and judicial proceedings of every other state. There's an English word for it, they call it committee, like having courtesy for other people's law, having respect for other people's laws. And that's the next, I didn't even know it was there. So now, judicial activity, the practice where judges make rulings based on personal or political consideration rather than existing law, often leading to significant changes in legal interpretation. We need to take note of this as well. Then subject matter competence. This is also a mechanism as well. This refers to the authority of a court or legal system to hear and decide cases based on the nature of the legal issues at hand. In the comparative perspective on the interstate and international dimension of conflict of laws in the Federation, subject matter competence plays a crucial role in determining how legal issues involving parties from different jurisdictions are resolved. Thank you so much. I will now hand over to my other colleague, Joy Ofuzo, to take the part two.
Okay, good evening, everyone. So to quickly run through part two, our part two considers a termed overview of federation. So as we all know that federation is a system of government where power is constitutionally shared between the central authority and other constituent authority. So we considered federation in Nigeria, that's the Federal Republic of Nigeria. We considered it as it operates in USA, and we considered it as it operates in Canada. So in Nigeria, as we know, there are 36 states in Nigeria and the Federal Capital Territory. The Constitution vests powers in the federal government as well as in the states. Now, this is provided for under the exclusive legislative list, itemizes certain items where power is vested majorly on the federal government to legislate upon. We have 68 items there where the federal government legislates. Then the concurrent list under part 2 of the second schedule to the Constitution provides for items under which both the federal government and the state government has powers to both legislate and deal with. For the sake of time, I'll quickly just move on to other jurisdictions. The United States of America has a federal district, and it has 50 individual states also, with Washington, D.C. as the national government. The Constitution of 1978 established federal system of government in the United States of America, and it operates through the legislative, the executive, and the judicial arm of government. I would like us to note that the states under the United States of America, by virtue of the powers in the legislative, vested in the legislative arm of government, they have their own separate laws as duly legislated upon by their legislative houses, and they have their own courts. And where there are disputes that concern them as they have their own courts. All states have their own courts, and they have the Supreme Court of the United States to consider matters that affect the United States as a federation. Then in considering Canada as a federation, Canada is a federal, bilingual, and multicultural. Canada has a federal, bilingual, and multicultural parliamentary democracy and constitutional monarchy as established in 1867. So it operates a decentralized form of federation where the executive federalism, where the prime minister and premier hold significant direct influences in the nation. Power is divided by the constitution, with the federal government managing national matters, just as we have in Nigeria, that we have the exclusive legislative list and the concurrent legislative list. That's how it also applies there. So I'll leave my other colleague to take over for the sake of time. Thank you.
Hello, good evening, everyone.
Good evening, man.
Just a moment. I'm Odeshala Happiness. Can everyone hear me?
Yes, I can hear you.
I can hear you too.
I can hear
All
you.
right. All right. I will be taking the part 3 of our seminal topic, and this covers the comparative analysis of the constitutional allocation of powers in Nigeria, USA, and Canada. Like we all know, the Federal Republic of Nigeria, United States of America, and Canada, they all operate a federal system of government, and they all have their constitution as the ground norms of different countries. The Constitution of the Federal Republic of Nigeria, 1999, as amended, provided for an executive legislative list specifying matters reserved for the federal government, which are legislated on by the National Assembly. The Constitution then further confers the various states in the Federation the power to legislate on matters not included in the executive list. That means they could go out of your jurisdiction or whatever powers that have been confined upon them. Similarly, in the section 1, in Article 1, Section 8 of the Constitution of the United States of America, they enumerate express powers to be exclusively exercised by the federal government. The 10th Amendment of 1791 then states that the powers cannot delegate to the United States by the Constitution, nor prohibits by it to the states, are reserved to the states. The reservations of residual power is the cornerstone of state autonomy in Nigeria and the United States. Similarly, as we can see in their Constitution Act of 1867, they actually separated the powers of the federal government and the provincial governments, because they run in the provinces, like provinces of the Alberta, New Brunswick, and the likes. The section 91 of the said constitution gives parliament authority over certain matters, while the section 92 of the Constitution Act of 1986 gives the province authority over local and private matters. The federation have their powers shared between the central government and the states or provinces. Like we know, they operate in provinces, unlike the US and Nigeria, whereby we run with states and all of that. Their powers is exclusive to the federal government, the states, and the federation, and residual powers not exclusively conferred on the federal government. In Nigeria and the United States, residual powers are confined on the states, and such states have the power to legislate on matters. However, in Canada, residual powers are conferred on the federal government, as can be seen in their Section 91 of the Constitution Act of 1867. It contains the POGG power, which could be stated as peace, order, and good governance, which also allows for federal government to legislate on matters not assigned to provinces, national emergencies, or matters of national concerns. The states or provinces in these federations are autonomous with respect to their status and choice of law methodologies, subject to the powers vested in the federal government. I would leave the chapter 4 for my group member, to take over. Thank you very much, class.
Thank you. Good evening, everyone. So I'll be talking on subject matter competence as well as state autonomy and conflict of law. So first of all, what is subject matter competence? Please, can we hear me?
Yes, we can.
Yes, thank you, sir. So subject matter competence simply means the court's legal authority to adjudicate over a matter based on the nature of the matter. For instance, is it a family matter? Is it contract? Is it maritime? That is basically what subject matter competence means. So now I'll be talking about subject matter competence in Nigeria. So now every state has an high court, and the jurisdiction of this high court is contained in section 272 of the Constitution. I would also like to refer us to the case of Madukolo and Nkem Dilim, where the court mentioned that subject matter is a part of the things that has to be considered before a court can assume jurisdiction over a matter. So now, the Constitution does not expressly state that the course of action must have happened in a particular state and only the state high court of that state can assume jurisdiction. However, in Nigeria, we've had several authorities where the decisions have been quite territorial rather than focusing on the subject matter competence of the courts. For instance, in Ogunde and Gateway Transit, where something happened in Lagos, it was an accident or something like that. Yes, an accident. And the matter was instituted in the Ogun State High Court. And at the Court of Appeal, it was held that the Ogun State High Court did not have jurisdiction to adjudicate over the matter because it arose in Lagos. So that is territorial. In that case, the court did not give regard to the fact that the Ogun State High Court had the subject matter competence over that matter. Okay, I'll be moving to subject matter competence in the US. In the US as well, the courts also have the same plights. States in the US also have their courts, and they also avoid adjudicating over matters based on territorial jurisdiction rather than subject matter competence as well. This is also the case in Canada. So I'll also speak briefly to state autonomy and interstate conflict of laws. So what is state autonomy? As the name depicts, it simply means the constitutionally guaranteed capacity of constituent units in a federation to exercise powers, be it legislative, judicial, or executive. So now we know that the judicial powers of the states, right, is expressed through the courts. Now, what are the things that limit this autonomy? In the US, we have something called the Restatement Second of Conflict of Laws. So this law is usually applied in resolving conflict of law matters, like in resolving conflict of law issues, right? And Section 6 of this law states that a court must follow its state's statutory choice of law rules, meaning that the courts in this state have the duty to follow the rules of that state when it comes to the resolution of conflict of laws. However, when the state does not have this law or rules in place, then the court must apply the most significant relationship test, meaning that the court has to weigh which of the jurisdictions have the most significant relationship. Now, in applying this test or the rules, as the case may be, the court must be guided by Article 2, Section 2 of the US Constitution, which provides that, which has to do with the fact that the President of the United States of America can sign treaties. So in applying this law or this significant test, regard must be made to the treaties that have been signed by the President. There's also the full faith and credit clause in the US. Now, this is contained in Article 4, Section 1 of the Constitution of the US. And what it simply says is that every state in the US must recognize the public act, record, and judicial proceedings of sister states. So what this means is that when a state makes a judgment, or when they have a law or something, yes, when they have an enactment, when they have laws or judgments, a sister state must recognize that judgment or that law. Okay, moving on. In Mills and Dury, the Supreme Court held that once a judgment is rendered by a state, it is conclusive in another state as long as the state that gave that judgment has the jurisdiction to adjudicate on that matter. Now, another limitation to autonomy of a state or state court, as the case may be, is the due process clause, which is contained in, is the due process clause. Now, what this means is that in interpreting this clause, the court in Home Insurance Co. and Dick held that a state should not apply its own law unless it has significant connection to the transaction in question. So once a state applies its law without having significant correction, that state has violated the due process clause. Now I'll be moving on to limitation of subject matter competence in Nigeria. So just as in the US, the laws of a state is foreign to another state, generally speaking. However, there's a provision in our Evidence Act that states that the courts must take judicial notice of the laws of other states, of laws within Nigeria. So I'd also like to mention that when it comes to service of processes, when it comes to interstate service of processes, this is governed by the Sheriffs and Civil Processes Act. Now, when the court in one state wants to assume jurisdiction over a defendant in another state, and then the processes have to be served outside, the writ has to be specially endorsed, stating that this writ emanated from this state and is going to that state, and that is contained in Section 103 of the Sheriffs and Civil Processes Act. Also, when it comes to enforcement of judgment, this also falls under what the Sheriff and Civil Processes Act gives the guidelines for. So for enforcement of judgment as well, the judgment of another state has to be registered in another state before such judgment is enforceable. That's provided for in Section 104 of the Sheriffs and Civil Processes Act. Now, with respect to foreign judgment, this is governed by the Foreign Judgment Reciprocal Enforcement Act. I'll be moving on to, okay, now I would also like to make reference to the case of Benson and Ashim, and also the case of Amanago and Okafor. So in this matter, right, the court held that the laws of, Okay, sorry, let me break it down. In Amanabu and Okafor, an accident happened in the north. However, the residents, the defendants, and the parties resided in the east. And what they did was they instituted the action in the east and wanted to apply the eastern law. However, the court held that that was wrong and that the law that should have been applied was the northern Nigerian law. So this is also what happened in Ashiri and Benson. So I would like to move on to autonomy of provinces in Canada. So basically, the provinces in Canada also have the same plight as the states in US and in Nigeria when it comes to territory. Now, when it comes to recognition of judgments, if we look at the case of Morgan Investment and Des Savoy, it was stated there that the court should recognize judgments of other provinces based on comity. That's mutual respect. Okay, that based on comity, the doctrine of comity simply means respecting the judgments, right, of other states, basically, without having to go through much procedural hurdles. So in the case of Morgan Investment and Des Savoy, it also mentioned that there should also be real and substantial connection to the matter before a court, a province, assumes jurisdiction. Okay. Also, I would like to refer to the case of Landrieu and La Chapelle, where the court addressed the conflict between Quebec and Ontario regarding property. Now, the court held that when it has to do with property, the law, the lex situs is what should be applied, meaning that the law of the place where the property is situated. Okay. So the reality of state autonomy and interstate conflict of law. Interstate conflict of law is not something that can be avoided in federal system of government. And conflict of law does not seek to put one territory over the other. So how can this interstate conflict of laws be resolved, right? We advise that the federal system adopt clear and predictable jurisdictional principles, and that the state courts should actually retain control of their courts, and that the federal, we also advise that rather than extensive federal preemption, we should adopt harmonization of private laws, or private law rules across the states. Also, we are advising against excessive discretion, as this wouldn't help in resolving conflict of law issues. And finally, for me, I would state that a well-functioning federal system does not eliminate interstate conflict of laws, but what it does is it manages it through a principled balance of autonomy, coordination, and judicial restraint. I'd like to hand over to my colleague, who will be taking over from here.
Thank you, everyone. Good evening once again. My name is Kolawole Uzamot, and I'll be taking part 6 of our paper, as well as the part 7. Part 6 talks about the jurisdiction and enforcement of judgments. In this part of our seminar paper, we talked about, or we addressed comparative analysis of jurisdiction and enforcement of judgments at interstate level in Nigeria, USA, and Canada. So, apparently the jurisdiction and enforcement of judgments at the interstate level are pivotal aspects of legal systems, shaping how individuals and entities navigate cross-border disputes in Nigeria, the USA, and Canada. So the legal frameworks in these areas exhibit significant variation, and of course, which are shaped by historical, legal, or cultural factors. In our analysis, we examine the differences and similarities between these jurisdictions, focusing on how each addresses the complexities of the interstate judgment enforcement. In Nigeria, for example, we rely on, or we enforcement of judgment in Nigeria is primarily governed by the Judgment Enforcement Acts and the Constitution, of which the Nigerian legal system is rooted in English common law, which influences its approach, jurisdiction, its approach to jurisdiction. For instance, we join constitution where the federal courts, denialate their, obtain their own jurisdictional power to decide on matters in the exclusive federal list, while the states also rely on state laws. Contrastly speaking, the US operates under a federal system in which each state has its own laws governing jurisdiction and enforcement of judgment. However, there is a clause in the Constitution which is referred to the full faith and credit clause, which mandates the states to recognize and enforce public acts, records, and judicial proceedings of every other state. However, this clause is a bit this clause serves a fundamental principle for the enforcement of interstate judgments, ensuring a degree of uniformity across all state jurisdictions. However, there is a particular challenge which arise concerning the scope of this clause, particularly in cases where there is variation in state laws. For instance, in family law, where the court is faced to adjudicate on divorce and child custody. Some states' laws varies, and of course, it hinders the court's ability to apply freely the laws of another state when the matter is being decided in another state where the provision of the state regarding that issue or that particular law is different. Similarly, in Canada, legal frameworks for jurisdiction and judgment enforcement is governed by both federal and provincial laws. The Canadian Constitution does not contain a specific provision analog to the full faith and credit clause. Instead, the enforcement of judgment in Canada is primarily regulated by the Uniform Enforcement of Canadian Judgment Act, known as the UECJA, which facilitates their recognition and enforcement across provinces. This UECJA aims to streamline the process, but its application may vary across provincial adaptation. Additionally, the Canadian legal system permits appeals of interprovincial enforcement decisions, creating a more complex judicial landscape than in the USA. The differences in enforcement mechanisms raise significant implications for litigants in each jurisdiction. In Nigeria, the absence of a uniform approach can lead to uncertainty and delays in the enforcement of judgment, particularly in cases involving parties from different states. Conversely, earlier on, a colleague referred to how adultery is not a crime in the South and how it is a crime in the North. So situations like that, of course, can lead to a kind of complex situation, hindering the court's decision over the matter. U.S. constitutional mandate fosters a more predictable framework, albeit it's with certain expectations that can complicate enforcement, while Canada's UECJ represents a middle ground, offering a structured yet flexible approach to interprovincial judgment enforcement that balances efficiency. I'll be discussing jurisdictional challenges and enforcement mechanisms now. Jurisdictional challenges and enforcement mechanisms represent significant areas of legal complexity, particularly in countries like the US, Nigeria, and Canada. Jurisdiction refers to the authority of a court or legal body to make decisions and enforce laws within a specific geographical area or over certain types of legal issues. Each of these countries has developed its own legal frameworks to address jurisdictional challenges, particularly in cases that cross states or national boundaries. The differences in these frameworks often lead to complication in enforcement mechanisms, particularly when dealing with transnational issues such as human trafficking, cybercrime, and international business disputes. In the United States, jurisdiction is a multifaceted issue governed by both federal and state laws. The US legal system operates under the principles of personal jurisdiction, subject matter jurisdiction, territorial jurisdiction. Personal jurisdiction refers to a court's authority over individuals involved in illegal proceedings, while subject matter jurisdiction pertains to the court's authority to hear a specific type of case. The U.S. Supreme Court has set forth guidelines such as the minimum contact standard established in the case of International Shoe Company versus Washington. The citation is provided in the footnotes in our seminar paper. This case was determined whether, in this case, it was determined whether a court can exert jurisdiction over an out-of-state defendant based on their connections to the forum state. These standards can complicate enforcement, especially in cases involving parties from different states or countries, as issues of due process and fairness are often raised. However, in Nigeria, jurisdictional challenges are influenced by a country's dual legal system, which incorporates both statutory law and customary law. The Nigerian Constitution provides a framework for jurisdiction, but enforcement remains a challenge due to the varying interpretation of laws across federal and state courts. Furthermore, Nigeria's legal state faces significant issues related to corruption, inefficiency, which can hinder the enforcement of court decisions. For instance, in the case of Apache versus Gani Fawehinmi, the citation is also provided. The Supreme Court of Nigeria addressed jurisdictional issues surrounding the enforcement of foreign judgments, highlighting the complexities involved in recognizing and enforcing decisions made in other jurisdictions. The case underscores the importance of establishing clear enforcement mechanisms to ensure that judgments are upheld across jurisdiction. In Canada, on the other hand, it presents a unique federal structure, like we said earlier, that complicates jurisdictional challenges. With both federal and provincial courts, a jurisdictional authority can vary significantly based on the nature of the case and the parties involved. The Supreme Court of Canada has played a crucial role in clarifying jurisdictional issues, notably in the case of Club Resorts Limited versus Van Breda. The citation also provided where the court established that a framework for determining jurisdiction in tort cases involving parties from different provinces and countries rather. The court decision emphasized the need for a real and substantial connection to the jurisdiction, which serves as a guiding principle for enforcement mechanisms in cross-border disputes. Summarily, jurisdictional challenges and enforcement mechanisms in the US, Nigeria, and Canada highlights the complexities of navigating legal systems that are influenced by variety of factors, including federalism, international law, and domestic policies. I'll rush quickly to part 7 because of time, which is our conclusion and recommendation. In conclusion, our paper provided a comprehensive comparative analysis of the interstate and international dimensions of conflicts of laws within federal systems, with particular reference to Nigeria, the United States of America, and Canada. We examined constitutional structures, subject matter, competence of courts, state autonomy, jurisdictional principles, and mechanisms for the enforcement of judgments. This study has also highlighted the diverse approaches adopted by these federations in managing cross-border legal disputes. We also adopted in our study significant doctrinal differences and policies considerations across the three jurisdictions, while interstate conflicts of laws in federal system involve balancing state autonomy with national coherence. International conflicts introduce additional complexities associated with sovereignty, reciprocity, and committee. The United States demonstrates a relatively unified approach through a full faith and credit clause. Canada, on its own, relies heavily on judicial doctrines such as real and substantial connection and interprovincial committee, while Nigeria continues to grapple with fragmented enforcement mechanisms and jurisdictional overlaps arising from its plural legal system. So in recommendation, we recommended that Nigeria's highly centralized, in the light of foregoing and particularly Nigeria's highly centralized federal structure, when compared with more decentralized models of the United States and Canada, our paper makes the following recommendations, uh, which are as follows. One, constitutional and institutional reconstruction in Nigeria. We recommend that Nigeria should undertake meaningful constitutional and institutional restructuring to devolve greater legislative, fiscal, and administrative powers to the states. Such reconstruction would enhance state autonomy, improve local governance, and reduce jurisdictional tension that frequently give rise to conflict of laws challenges. We also recommended harmonization of jurisdictional standards. For instance, clearer and more uniform jurisdictional standards should be adopted across federations. Courts should consistently apply objective connecting factors such as domicile, place of performance, and real and substantial connection when determining jurisdiction, thereby reducing forum shopping and enhancing predictability. We also recommended that reform of interjudgment enforcement in Nigeria, that Nigeria should harmonize its procedures for recognition and enforcement of interstate judgment through comprehensive legislative reform, a unified statutory framework comparable in effect to the full faith and credit mechanism in the United States or Canada's doctrine of interprovincial committee would promote legal certainty and facilitate smoother enforcement of judgments across state boundaries. We also recommended limited harmonization of private law rules. For instance, it is a recommendation that federal system should encourage limited harmonization of private law rules through model laws, judicial cooperation, and intergovernmental agreements. This approach preserves the state autonomy while minimizing inconsistencies that generate conflicts of laws difficulties, particularly in commercial and family law matters. We also recommended limited harmonization of private law rules, that judicial capacity building should be prioritized, especially in developing in developing federations such as Nigeria. Continuous professionals trainings for judges and legal practitioners in conflict of laws principles and comparative methodologies would strengthen judicial consistency and improve the quality of cross-border. Off record, we give credit to the Lagos State judiciary, who thereby always engaging their judges and magistrates in retreats and giving them opportunities for exposure, across other jurisdiction and international jurisdiction, so that they can apply and also manage conflicts of laws. Strengthening intergovernmental cooperation, greater intergovernmental. Yes, sir.
Please.
Yes, this is the last one actually. This is the last point. So the last one says that greater intergovernmental dialogue and cooperation among constituent units should be institutionalized. Regular collaboration between federal and state authorities, alongside engagement with international legal frameworks, will assist in addressing emerging challenges associated with globalization, migration, and transnational commerce. This is our work, sir. Thank you, class. Thank you, Prof.
Okay. Class, you have listened to their presentation. We can accommodate one or two comments before I make mine. If we must do all that we plan to do today, they've already taken too much of our time. So one or two comments.
All right, sir.
I think it's too
Good day,
long.
sir.
It's too long. The work is too long.
Good day, sir.
Well, I don't know. That has been my experience these days with seminar papers. Some seminar papers you can discuss all that you want to discuss in not less than 10 pages. But because we are putting 6 people there, and everybody wants to have an input, and maybe coupled with the fact that both of us are not really familiar with the subject, we then expand it sometimes beyond the scope of what is desired. But any research effort should be commended because it's not easy to sit down, think about what a seminar topic requires, and go about adding the thoughts of 6 people to present something. So maybe we should be generous in our commendation. Otherwise, I would have agreed with you that it's too much. But let's have one or two comments before I make mine.
All right, thank you, sir. My name is Abiodun Adebayo.
Yeah.
Can I go on, sir?
Please do.
All right, sir. I want to actually commend the presenters, especially their recommendation. They're very buoyant and progressive. But I actually have need a clarification, can I say, because they talked about federal legislation and make reference to section 4.1 of our constitutions. And when we look at that, I want to believe that when you talk of federal legislation and state legislation in Nigeria, that we can't be talking about conflict of law in that aspect. We should rather be talking about the principle of inconsistency as stated in section 4.2, and also the principle of covering the field. So I don't agree with them in that aspect that there is issue of conflict when the court, because the content is very clear when that of the state is inconsistent with that of the federal prevails. And when federal has legislated on a particular issue, the state cannot. So we talk about doctrine of conferring the fees. That's my own observation from that point, sir. Thank you, sir.
Yeah, very well. Very well. Well, your comment highlights the mix-up. Do you understand? It highlights the mix-up between what exactly is the field of conflict of laws and where does the field of constitutionalism begin? Okay? In our definition of conflict of laws, I introduce a term or two terms, horizontal and vertical. The type of conflict we often talk about when we talk about federal state legislature or federal state competence conflict is not our business a conflict of law. It's a vertical conflict. Vertical in the sense that for two things to be related in a vertical manner means that there is a hierarchy. And so one must succumb to the other. So a federal state conflict is a vertical conflict. It's not our problem in conflict of laws. Our problem in conflict of law is the horizontal one. Typically, you have And then there is another very common error. We stated in our definition that this subject relates only to civil law. So giving me an example of adultery being a crime somewhere, not being a crime in other places, it's not our business in private international law or conflict of laws. Okay? Because if you look at it strictly, if somebody commits adultery in the northern Nigeria, are you saying that because he may have come from southern Nigeria, therefore the penal code will be suspended for him? Do they suspend penal legislation because of the personal connecting factor of the offender? It's not done. So those are not issues of private international law. They are not issues of conflict of laws. You are dabbling into public law, and it's never our business in the area of public law. We are never interested in differences between public laws of two states, because connecting factors are not really relevant in public law. If a person is to be tried for a crime, he will be tried for a crime at the place where he commits it. And the only law that the court will look at is the law of that state. You will not come and say, oh, where he came from, that thing might not have been an offense. Crimes are territorial by nature. The state legislature or the legislature does not enact a crime and then begin to distinguish between people who are from one place and people who are not from that place. So if the legislature of Lagos makes bigamy an offense, you cannot say that because you are from Ekiti, you will have a right to take a second wife in Lagos. That doesn't happen in criminal law. So next time when you are discussing this subject area, you should know the limit. Giving example of adultery is a clear demonstration of lack of understanding of the scope of this subject. Now, when I started, I said this is supposed to be a small topic, but our presenters have made it wider than our imagination. Okay, but let me tell you what I actually wanted you to discuss. We have been told that there are 3 questions in conflict of laws. And we have been told that there are 3 dimensions. 2 of the dimensions they cover all the 3 questions. The international dimension, which we call private international law, covers all the 3 questions: choice of jurisdiction, choice of law, recognition, and enforcement of judgments. Interstate also covers choice of law, choice of jurisdiction, recognition, and enforcement of judgments. So we are saying that in the same way that it could be an issue whether a Lagos High Court would apply Ghanaian law to determine liability for an accident that occurs during a journey from Kumasi to Lagos. That would be a question of choice of law for the Lagos High Court. Am I going to apply Nigerian law or am I going to apply Ghanaian law? The same issue could also arise in the context of where the parties are taking off from Ibadan and the accident occurred at Ogiri when they are headed to Lagos. So, but in the one case, the question will be, which am I to apply between Ghanaian and Nigerian law? In the second instance, the same question will arise in the interstate level, which am I to apply between Oyo and Lagos law? Okay? So, interstate and international choice of jurisdiction could arise. Again, that is choice of law could arise. Choice of jurisdiction could also arise because the Lagos court would have to be determining why come to Lagos when the accident occurred in Seme. Why not go to Seme? That's choice of jurisdiction question. The same issue could arise. A Lagos High Court at Ikeja can be looking at the issue. This accident occurred in Ogiri, but you are here in Lagos to sue. And if the Lagos High Court does not know the law, as the Supreme Court demonstrated lack of knowledge, the Lagos High Court could be saying, no, it's Ogiri, you will go, not Lagos. Okay? So, choice of jurisdiction could also arise at the interstate level. Enforcement of foreign judgment could also arise at interstate as well as the international level. You could obtain judgment from Ghana, but the asset of the judgment debtor is in Lagos. And so you will need the permission of Lagos law to be able to enforce that judgment in Lagos. In the same way, you could obtain judgment in Ibadan, but the asset of the judgment debtor is in Lagos. So at the interstate level, enforcement of foreign judgment can be an issue. And in both instances, you will be needing the Lagos rule of enforcement of judgment to permit you to enforce a judgment that you have obtained in Ibadan. Just as you will be needing Nigerian rules on enforcement of judgment to permit you to enforce a judgment that you have obtained in Ghana. So you can see that in theory, the questions are the same at the interstate or the international level. What we wanted you to discuss is that are there special federal provisions that tend to limit a legal district's power to formulate whether a rule of choice of jurisdiction or a rule of choice of law or a rule of enforcement of judgments. Okay? So, for example, you did well by showing us that in America, they have a full faith and credit clause, which therefore forbids one state from questioning legislature and judgments of other states. Now, at the international level, rules on enforcement of judgment of other countries will permit the court of the state where the judgment is sought to be enforced to refuse to enforce on ground of public policy. Can you do that if it is interstate? In America, is it possible for one state to say on ground of public policy, I'm not enforcing the judgment of obtained in another state? It's not possible. Somebody asked me a question one time. Say, look, Nigeria, we are a federation, and the section 104, 105 of the Sheriff and Civil Process Act is saying that all you need to do is to obtain a judgment you have to obtain certified true copy of a judgment you have gotten in one state and get it registered in the book known as Register of Nigerian Judgment in another state. And for all intents and purposes, it becomes the judgment of the state where you have registered it. Then somebody asked me the question, what if the judgment was based on, say, Sharia in Kano, Shouldn't Lagos be able to say, look, this judgment was based on a law we don't accept? Argument like that will fall under public policy. But is that possible in the interstate situation? So you see that there's a slight difference. There are some of the powers that forums will have to reject or to refuse to register foreign judgment at international level that they will not have at interstate level because of provisions like full faith and credit clause in America compared to the equivalent of full faith and credit clause is in our Evidence Act, which mandates every court and authority in every part of Nigeria to take judicial notice of every act and legislation and judgment of another state. It's there. It's in the case of Benson and Ashiru, the Supreme Court referred to it to say that, look, I don't need to wait for you to specifically quote for me what the law in Western Nigeria says because you are suing in Lagos. As a judge, I'm supposed to take judicial notice of it. So you will see that whereas in theory it is the same issue, but in the interstate level, there's a limitation to the discretionary power of the forum court because of those type of things that you have. By far, the most important thing I usually want people to discuss is the question of autonomy. What do we mean by autonomy? In practice, every legal district might enact a substantive law differently from the substantive law of another legal district. Is that not so? Hello?
We are with you, sir.
So in theory, Nigerian law may not be the
Sir,
same
we didn't
as
get that
Ghanaian.
part, sir.
Which part did you not get?
You said in practice, every legal dispute might what, sir?
Every legal district might enact a substantive law to be different from the substantive law of another legal district. So Nigerian law may be different from Ghanaian law in the example I gave. Okay? In the same practice, Lagos law may be different from Oyo law. Okay? But you will find that in a federation, there are sometimes federal arrangement that does not make that to happen. The arrangement may be legislative, may be historical. Okay? In Nigeria, for example, and I normally use the conflict of tort law cases to illustrate that. In Nigeria, can you really tell me that Lagos State tort law is different from Oyo State tort law? Is it possible? Can you distinguish between Lagos State tort law or Oyo State tort law? You are likely to find that every piece of legislation touching on the area of law of tort in Lagos exists also in Oyo, because historically they were under the same, probably under the same Western region. And it is the same Western regional law that each state adopted when it was carved out as a state. Then, so much of the tort law of Oyo that is not legislative will come from the common law, and we all inherited the same common law. So you now find a situation where you now find a situation where an event, a thought event, which would have been determined by the same substantive law, whether you are in Lagos or you are in Oyo, we of our own try to make an issue out of it that is it Oyo law you are applying or is it Lagos law you are applying? So you are likely to find recurrence of what we call force conflict more in the interstate conflict of laws than the international. What do we mean by force conflict? Substantive laws are the same. If the case was going on in Ibadan and you apply on your law, the answer you will get will not be different from if the case was going on in Lagos and you apply Lagos law. But because of lack of mastery of what this subject area is all about, we make an issue out of the difference in territory and we end up confusing ourselves. And that is what I use Amanambo and Okafor to illustrate. In Amanambo and Okafor, the accident that occurred in northern Nigeria. Northern Nigeria had a fatal accident legislation, a received English statute, okay? But the content of that legislation is not different from that of any other state, including the one that is enacted by other states in Nigeria. So it would then mean that if that accident had been sued upon in northern Nigeria, and northern Nigeria law applied, it is the same judgment that the court will give, that the court in Eastern Nigeria will also give if the accident was sued upon in Eastern Nigeria and Eastern Nigeria statute is applied. So there is virtually no conflict between the statute, or at worst, you call it a forced conflict because the substantive laws are the same. The substantive laws are the same. But you see what the court, you see the mess the court made out of the case. In the lower court, the court said, one of the court said the proper thing to do was to rely on Eastern Nigerian law or something. The other one said, no, how can an Eastern Nigerian court be applying Northern Nigerian law? Whereas in reality, there's no difference between the Northern Nigerian fatal accident legislation and the Eastern Nigerian fatal accident legislation. So the comparison then means that a lot of attention will have to be paid to how states in a federation take their autonomy. There are two issues that autonomy relates to. One, substantive law. For example, nothing stops Lagos from changing her thought law dramatically so that it will be fundamentally different from that of Oyo, because it is a subject area in as well which Lagos can legislate. But insofar as Lagos has not done that, we fail to understand the peculiarity of the interstate dimension of conflict of laws when we make an issue out of the territorial difference. Okay, but you go to a state like America, you find that all of the two issues, the result of which autonomy can be exercised, the states take them seriously. The first one is substantive law. As you are moving from one territory in the American Federation to another, you will be noting the differences in their law. Some states, we usually give example of gratuitous passengers. There are some states in America that will say that owner drivers are not responsible when injury occurs to gratuitous passengers. When injury occurs to gratuitous passengers, and there are some other states that do not have that law. So you find cases like Babcock and Jackson. You find cases like Babcock and Jackson, where the law of the place where the parties took off from has no such provision. But the accident occurs in another state, which has such a provision that the owner of the car will not be responsible when injury occurs. So that's the substantive law. You also need the conflict rule. Now, when the party went back to sue in the state where they took off from, the state would now have to apply its own conflict rules. And its conflict rules was different from, its conflict rule was different from the lex loci delicti rule. The lex loci delicti rule, which is the predominant conflict rules in that area, the state where they took off from refused to apply it. Instead, it applied the rule of the law with the most significant connection. So in that way, it ended up saying that it is the New York substantive law that will govern the matter, and ended up imposing liability on the owner driver. If it had applied the conflict rule lex loci delicti commissi, it would have ended up applying the law of the state where the injury occurred, which law had actually exonerated the owner driver. That is conflict of laws at play. Two issues in respect of which states exercise autonomy. One, their substantive law. Two, their conflict rule. In an American federation, where you can see autonomy in display, such cases as Babcock and Jackson and other cases illustrate what could result from such a situation. But in a Nigerian federation, where both the Eastern Nigeria and Northern Nigeria would apply the same common law, choice of law rule, and both the Northern and Eastern Nigeria have the same substantive law, what is the sense in making so much noise about the fact that the accident occurred one place and the action was taken in another place? So all the point we are trying to make is that, yes, in theory, all of the three questions, jurisdiction, law, enforcement of judgment, could arise in both interstate and international dimension. But in the interstate dimension, the federal arrangement between the component states can sometimes mean that the autonomy of legal districts have been taken away from them, and therefore the conflict of law dimension of the issue has been watered down. So that is the point we are trying to make. I think in a paper I wrote, which I titled "Interstate Conflict of Tort Laws." Interstate conflict of tort laws, much ado about nothing. I highlighted all these points. So, in summary, all of the questions at interstate level, at international level, could arise at interstate level, but that is in theory. In practice, the nature of the federation and the history of relationship between federating states, uniformity of laws, and what have you, can mean that states as legal districts have lost their autonomy, and what is like a conflict of law situation will be treated as if it is a local situation. That is the point we want to make. Okay? So go and read that paper and get my gist. You understand? Comparing America with Nigeria, for example, you find that the issue of the federation, the issue of their federalism is not the same with our own. The issue of their federalism is not the same with our own. The states in the American Federation are not only territorially autonomous, they are, in terms of their laws, very autonomous. And that is whether it is their substantive law or it is their conflict rules. As you move from one American state to another, you will see that this Lex Loci Delicti committee that we use in tort is not uniform. Some states will do government interest analysis. Some will say they are applying law with the most significant connection. Some will say they are applying the proper law of tort. It is within their autonomy to determine the choice of law rule they will apply. When do you see that happening in Nigeria? We all apply the same uniform choice of law rule because we will rely on common law. Even our substantive law, they are not different. Had it been that our substantive law in most areas where civil conflict will arise are different, we would not have been able to operate the same bar. A student studying in the University of Lagos would have had to know Lagos tort law, which will be different from Sokoto tort law. But you find that in our syllabus, we teach the same law of tort because largely the statutes are the same. When you are not applying statute, you are applying common law, which we uniformly adopt. So, de-emphasizing the territorial gap in interstate conflict cases is probably the proper thing to do, instead of applying the theory without recognizing the nature of our own federalism. That's the point one is trying to make. Go and read that article, and you'll be able to get what one is saying. So I think on that note, I have how many more minutes? I have about 20 more minutes. So let me talk to the remaining two topics. Amen. The first one, personal connecting factor. When we talk about personal connecting factor, we are basically referring you to the subject area of law of personal status. Law of personal status. What are the subject matters in that area? Beginning with marriage. You have marriage, you have matrimonial causes, you have inheritance, and what is called succession. Okay? Whether succession to movables or succession to immovables. You have legitimacy, you have legitimation. Okay, all of these are status subject matters. And in private international law, what states do is to have a formula for attaching people to particular legal districts. And once that is done, whenever the issue in dispute falls within the subject area of status, it is the law of that legal district that a person has been attached to that will be applied. So in other words, you want to attach people to the law of a particular state, and you want to presume that they carried that law from their state into other states. So if a litigation is going on in your home country and they are involved, and the litigation relates to those subject area of status, you do not bore yourself you do not crack your brain. You just use that formula to say, this person belongs to this state. That's what we are saying. When the Supreme Court was saying, if one state matter, you don't take one state matter to another state. The Supreme Court jumped the gun because the Supreme Court does not tell us on what basis do you determine that one matter belongs to one state or the other. But personal connecting factor is a formula for determining which state law will govern a person in the area of personal status. And different legal cultures, okay, do not use the same formula. Distinction can be broadly made between the civil law legal culture and the common law legal culture. The civil law legal culture would apply nationality. The common law legal culture will apply domicile. So the common law legal culture will say that where there is a litigation in any subject area of personal status, and the litigation is the type that will fall under private international law, what you would apply to determine the applicable law is the domicile of the propositors. So, for example, England is a common law country. Two Ghanaian citizens domicile in England. Okay. When the issue is as to succession to the intestate estate of either of them by the other, the English court, knowing fully well that they are Ghanaians, will nevertheless apply English law because the connecting factor that England uses is domicile, and their domicile in England. Suppose the same two persons, being Ghanaians, were however domicile in France, and an action is going on in the French court. Okay? And the French court is to determine what law to govern the intestacy of the deceased one among the two of them. The French court or the Italian court will apply Ghanaian law because their own connecting factor is nationality. Okay? So, what we want the presenters of this paper to do is, because this is a comparative class, is to look at the different connecting factors that countries use. There are three of them. There is domicile, there is nationality, and some countries use some advanced form of residence, maybe habitual residence, okay? Maybe ordinary residence or whatever, okay? With regard to domicile, which is our own, which is the one we share, Nigeria uses domicile as a common law country. It's what we received from the received English law. You need to explain to us the detailed meaning of domicile, the types of domicile, the rules of domicile. You need to be able to compare domicile with nationality. It's often said that our domicile is the more appropriate of the two tests, but it is usually very difficult to determine. On the other hand, nationality is the more certain of the two tests, but if you look at it under modern condition, it is probably inappropriate. So it's a straightforward paper. What we want you to say, I've actually told you. Okay? And it should not be difficult for you to say. So that is that with personal connecting factor. Okay? Or the other title for that is domicile, nationality, and habitual residence as comparative connecting factors. Okay? So the other topic is marriage. Marriage is a very wide topic, and we will have to break it down into at least minimum of two. Marriage and recognition of foreign decrees. We can break it into three by discussing validity of marriage, polygamous and monogamous marriage in conflict of laws, and foreign nullity and divorce decrees. Okay? So under marriage, those of you who did family law, you know what the issue usually are in marriage. Validity and formality and capacity. What determines the validity of a marriage? A marriage must be formally valid. And then the parties must have capacity to enter into it. So when we are talking about formal validity, what are the issues? What are the issues to discuss? Okay. Issues like date, location, prescriptions of the relevant marriage statute. For example, on marriage certificate, on issue of bans, on officiating minister. If you solemnize your marriage in a church, for example, some countries will insist that the officiating minister must be specially licensed. Others will say it is sufficient, that is an ordained pastor. Things like this are all issues of form. Okay? Then you have parental consent, which is an issue of form too. And so, what is the connecting factor for form? They will tell you is lex loci celebrationis. Are there any exceptions to lex loci celebrationis? Are there instances when you marry in a country not according to its law, and other countries would accept that you have married? That's what we mean by exception. Okay? So you have to know the exception to lex loci celebrationis. You have to know the implication of not complying with lex loci celebrationis. Okay? Then when you come to capacity, the one that in family law you call essential validity. Such issues as prohibited limit of affinity, prohibited limit of consanguinity, age of marriage, whether or not previous marriage was rightly dissolved. For example, if you dissolve your previous marriage in a country that you are not domiciled, and you want to carry that your new status to another country to remarry, okay? Do you need that country to accept that you are formally divorced? Or do you need the country in which action is now filed for dissolution of the new marriage or nullity of the new marriage to even recognize that you are qualified to enter into another marriage? Then there is the issue of polygamous marriages. There is the issue of polygamous marriage. What is a potentially polygamous marriage? English law does not recognize polygamous marriages, does not accept polygamous marriages to be conducted in England. But does it mean that If a person did a polygamous marriage in another country, having capacity to do so, will the English court, English or Nigerian court refuse to recognize that he's married? Then conversion. Polygamous marriages can be deemed converted to monogamous one. Okay? What are the incidents that can make a Nigerian or an English court to accept that a potentially polygamous marriage has become monogamous? We have such factors as change of religion, we have such factors as change of domicile, we have a number of other things that the cases have recognized. So you have to discuss them. Then the second or third paper, as the case may be, which is recognition of foreign divorce decree. What we are saying in that one is that people could dissolve or nullify their marriage. People could dissolve or nullify their marriage in one country, and the consequence of that nullity or dissolution would have to be considered in another. For example, if the spouse of a dissolved marriage wants to remarry in Nigeria, somebody can raise a caveat that the pre-existing marriage is still on because Nigeria will not recognize the decree of dissolution that you obtained. So you could then have what you call limping marriage. That is a situation where people are considered divorced in one country, but they move to another country, they are considered still married. So every country must have a rule for recognition of foreign divorce or nullity decree. Otherwise, the decision of marriage will be bastardized. You will have situation where whether you are married or not will depend on the country you are or the country you are litigating. So countries of the world try to ensure that they widen their formula for recognition of foreign divorce decrees. But incidentally, the matter is regulated by our own matrimonial causes decree, section 81. Go and look at section 81 of our decree and look at textbooks on conflict of laws. You will be able to highlight. You will be able to highlight the grounds for recognition of foreign divorce decrees. So I will forward to you some previous lecture notes so that it will guide whoever is going to write in this area to do a good job. Although the note might not cover all the topics. Okay? I think it's one particular slide that I normally use to discuss the subject that I will send to your class governor, let him forward to you. Otherwise, all the other discussions are textbook discussions. So, see you next week. It's time for me to go.
Prof,
Prof, sir, thank you so much for the class, sir. I think what we have left is topic 9, which is the thought in conflict of laws. I think we can discuss that.
Have you distributed personal connecting factor before?
Yes.
Okay, you distributed marriage too.
Yes, sir. We've distributed personal connecting factor and marriage. But now that you made mention of we should divide marriage into minimum of 2. So I would divide the members into 2 subgroups.
Okay. So next week when we take the topic of next week, I can also talk to you on the thoughts.
Oh, okay, sir. So we have group 4.
I just hope we will have the time to cover thought too. At the rate we are going. If we don't cover thought, we will do it in second semester.
Okay.
I think we should just take it that we start with thought in second semester. Let's leave
Yes, that's fine, Paul, sir. That's fine.
Thank you very much, Prof.
God
bless you, sir. Yes, sir.
Oh, thank you, sir. God bless you, sir.
Thank you, Prof. Thanks for your time.
Prof, we appreciate your effort, sir.
Thank you very much, sir.
Prof. Thank you so much. Apologize for misleading class with penal code.
No, when it's all in the course of learning.